All right, good morning and welcome. My name is Russell Farbiarz, and I am your estate planning attorney at Antanavage Farbiarz. And we are pleased to present to you with our estate planning and asset protection workshop. And it wouldn't be a complete webinar if there weren't a couple of technical difficulties. So I'm sorry for that brief pause that we just had. But what I we are going to do is we are going to move forward with our presentation. Okay, and it also wouldn't be a presentation with an attorney if we didn't have a disclaimer that says that the opinions expressed in this presentation um, are those of the presenter, and there is no attorney-client relationship created by attendance here, but of course, we will be providing you with opportunities to engage us for your estate planning later on in the presentation. So the first question you may have is, who am I? As I said, my name is Russell Farbiarz. I am an estate planning and elder law attorney, and we have two offices. One office in Hamburg, Pennsylvania, in the northern part of Berks County, and we also have an office in Wyomissing, Berks County, and we work with clients throughout the eastern part and middle part of Pennsylvania, meeting with clients both virtually and in person. I am the managing attorney at Antanavage Farbiarz, and in addition, I am I am also the owner and title agent for a title company called Northeast Berks Abstract. You might wonder why I mention that in an estate planning workshop, but the primary reason is that a lot of times what we are planning for involves real estate. So I think it's important for you to know that in addition to being incredibly knowledgeable on estate planning and elder law topics, I'm also experienced in real estate and title issues. What we're going to be focusing on today, however, is how to make a plan to protect your estate, manage your assets, and leave a legacy for your loved ones. Now, I will invite you that if you do have questions or anything along those lines, you can put those in the chat or in the Q&A, and I will do my best to be able to answer those for you. So I want to give you a quick outline of what we're going to talk about today. We're going to start with people, assets, and priorities, and really just get into what is estate planning, because we hear the phrase, but what does that mean? And then we'll talk about some of the elements of a basic estate plan, and then I do want to spend a few minutes talking about asset protection. There's a lot for us to cover. I'm going to go as quickly as I can. I understand that your time is valuable, and I know you don't want to be sitting on a Zoom for hours learning about this. So I will move through the material as best we can. So the first question is, well, why plan today? This is why is it important that we do this today? Why not put it off till tomorrow? Well, the problem is that when you put off your plan until tomorrow, you don't know what tomorrow is going to bring, if tomorrow is going to be a better day or a better time to create your plan. And if you wait to create a plan, and now you have an emergency, you have a health crisis, uh, perhaps you are start suffering from things, some ailments such as dementia, you can make what would otherwise be a simple plan a very complicated plan. You certainly you could create an emergency that is going to now make it more difficult to implement a plan and implement the plan that you want. Um, and you are also now um, going to create a situation where it could also be far more expensive, unfortunately. So what is estate planning? As I said before, we hear this term thrown around, but what exactly is it? So before we can answer what is estate planning, we need to talk about what is your estate, because you need to know what you're planning for. And a lot of folks say, well, I don't have much. I don't have an estate, so I don't need to do a plan. Well, I'm here to tell you that's by and large not true. Almost everyone has some type of an estate, because your estate consists of anything that you might own. If you have a bank account, you have an estate. If you have an investment account, you have an estate. Life insurance, and especially if you own real estate, you most certainly have an estate. If you own a business, if you have a personal property collection, if you own pets, anything that you own would consist of your estate. So then, once we've established that you do have an estate, then who what are we doing with it? Why are we planning? So the first question is who? Who do you want to create a plan for? Are you creating a plan for you? Do you have a spouse that you want to make sure is protected? Maybe you have maybe you're the primary breadwinner in the family, and you want to make sure that your spouse is protected. You have kids, especially if you have minor children or children uh, who need care and need to be taken care of. Uh, do you have do you have children who have special needs, or or children who are disabled, that you need to plan for? Do you have certain assets that you want to make sure get to a certain person? And do you have some priorities, such as you want to make sure that the least amount of taxes go to the government? See, I hear that one all the time, is that we don't want things to go we don't want anything to go to the government. Um, so you, we want to make sure that everything gets taken care of. Maybe you have some family harmony issues that you need to address. Maybe you have some asset protection concerns. Uh, you want to make sure that your assets are protected for your beneficiaries. You don't want them to necessarily go to, as I mentioned, to the government, to a nursing home or whatnot. Uh, Maybe you want to just make sure that you have someone in charge if you get sick and you can't take care of yourself, because as we're going to talk about in a few moments, estate planning is not just about what happens when you die, it's also about what happens as you're getting older. And so it's important to make sure that you have a plan, not just for your death, but also for your life. So the way that I like to talk about this is that your estate is like a wheel with you in the center as the hub. And your there are various different components of this. So you have your different legal rights and responsibilities. That includes your ability to decide who's going to make financial decisions for you, who's going to make healthcare decisions for you, where you're going to live, who's going to have who's going to have control of of your stuff, your house, your bank accounts, your personal property, your collections. You know, if you become incapacitated, if you become sick and can't take care of them, and then ultimately uh, when you would pass away. And then you also have to make sure that as I mentioned before, you've made your healthcare decisions. Maybe you want to decide in advance what care you do or don't want to receive if you're suffering from an end stage medical condition. And then often most important is your loved ones. You want to make sure that your loved ones are protected, that you have and you've continued to provide for them even if you're incapacitated or have passed away. So what's the problem here is if we take you out of the hub of the wheel, the whole thing falls apart if you don't especially or really if you don't have a plan. And if you don't make a plan for yourself, let me tell you, the government has a plan for you. And it in most cases is not the plan that you would pick for yourself. So if you don't do your own planning, there are local rules. They're called the rules of intestate succession, and they are going to govern or control who the who is in charge. Those rules are going to decide who the fiduciary or who the executor or power of attorney is. They're going to These rules are going to decide who gets your stuff, who gets to inherit from you, and maybe it's not who you would want or who you would think it should be. And because the government is now choosing for you who your beneficiaries are and who's going to inherit from you, you don't have the ability to plan for tax efficiency. So you may end up paying more in inheritance taxes than you otherwise would. And I'm going to tell you for certain, the government is not planning to protect your assets because the rules of intestate succession are not designed for asset protection. They're they're just designed to make sure that there's a way for assets to go from one generation to the next. And if one of your priorities is protecting assets, if you don't have a plan, it's not going to happen for you. And I think really the most critical issue here is that if you don't make your own plan, you lose absolute control over financial and medical decisions. If you become incapacitated, and you don't have a power of attorney in place, the court is going to decide who makes decisions for you. If you don't have a will or a trust in place, the rules of intestate succession are going to decide who inherits from you. You don't want this. You want to maintain as much control as you can so that you can decide who's in charge and who receives your assets. So, as I've pointed out, maintaining control is one of the primary reasons to have an estate plan. The second is you want to make sure that you have an efficient transfer of wealth. You want to make sure that those assets go to the next generation, and you do that in a way that reduces taxes as much as possible. And finally, you want to protect your beneficiaries. And when I say protect beneficiaries, a lot of times what we're talking about are children or those with special needs, because if you have children who are young, you don't want them to necessarily inherit something at age 18. You want to make sure that you protect them sometimes from themselves to make sure that they are able to use those assets in the best way possible. And sometimes if you have a beneficiary who has special needs, you want to make sure that they are protected and can continue to enjoy any government benefits that they need, while also being able to improve the quality of their life. So whenever we start talking about an estate plan or planning for someone's estate, one of the important things to talk about are goals, because we want to know, and as an estate planner, I want to know, what is it that you are looking to do? What do you want to make sure that you plan around? Because everyone can have different goals. Are you looking to minimize or eliminate probate? Is asset protection your priority? Is it controlled? You would just want to make sure that you can direct where your stuff goes. Are you looking to leave a charitable legacy? All of these are very important, valid, noble goals. We just want to make sure that those goals are reflected in your plan. Now, this is important though. We talk about goals. We talk about estate planning, and a lot of times, folks believe estate planning. Well, that's not for me. That's for someone else. That's for only for the super rich. But the reality is that today estate planning is for everyone, because while 50, 60, 70 years ago, maybe estate planning was primarily an estate tax issue where people who were trying to avoid estate taxes. That's not the goal or the motivation today. The purpose of estate planning is simply to create a plan so that you can transfer your assets to the next generation, uh, so that you can achieve your goals, whether it be family harmony, whether it be asset protection, beneficiary protection, whatever it is that you think needs to be the goal and what you find important. But again, don't let the government make the goal for you. You want you want to make the plan. Okay. So we're going to move on now and talk about documents that you must have. Now that we've talked about why it's important to do the planning, what exactly does that plan consist of? So the first document is the will. So I think most people have heard about a will. It's very simply defined. It's a document that's signed in a prescribed manner, as prescribed by law, that disposes of property at your death. It says, this is where my stuff goes, and it also says, this is who's in charge. So in the will, you're going to nominate your executor. That's who's in charge. That's who's going to make the decisions for the estate and make sure your wishes are carried out. You also have the ability to nominate a guardian for your minor children. So if you have minor children, you want to make sure that you have the will a will set up, because you can indicate in the will who you want your children to live with if you would pass away early. And then finally, you would direct when and how heirs would receive their inheritance. This consists of who's going to receive the inheritance, and then when are they going to receive it? Are they going to receive it all now? Are they going to receive some of it in trust and have it be distributed over time? The will also is a document that can change and live with you, because the will is not effective until you die, until it's probated. So don't one common mistake can be, well, I'm not 100% sure. I might change my mind, so I want to do this later. Do it now, because you can always change it. The will is not effective till it is probated. And probate, it's another word that maybe can seem a little scary, because not everyone knows what probate is, but probate is really just all it is a court process that determines the validity of the will and empowers the executor to act. And here's the even better thing, is that probate used to involve going into the courthouse and you know gotta find parking, you gotta go inside. It's not that way anymore. One of the improvements that we have as a result of the pandemic is that probate is now done via Zoom or via video conference. So You can do probate in the comfort of your home or more likely in the comfort of your attorney's office. And it's easy, it's accessible, and honestly, it doesn't take all that much time. So what happens is that the at probate is simply that the will is submitted and it is the contents of it are proved, and once that occurs, then the executor is able to act, but it has no effect until the time until that probate is complete. And then the other thing I'll note about probate is that it's a public process. So if privacy is a concern, this is not necessarily the process that works as well, because everything is going to be out in the open, and publicly accessible. So I talked to you about what the will does, but one of the things the will does not do is that it doesn't provide for the incapacity of the maker, because as I mentioned, it only becomes valid after you die. So if you become incapacitated in the later stages of your life, the will is not going to do anything to help you in that regard. And that's why the second document that you absolutely need as part of your estate plan is your durable power of attorney, or your durable financial power of attorney. And what this document does is it designates a person who's authorized to make financial decisions on your behalf. Document is effective on the day that you sign it, and it's durable. So what does durability mean? Durability means that if you become disabled or incapacitated, it still works. Your agent can still make decisions on your behalf. And that is what most of us need if we suffer from incapacity or disability. We need someone that we choose, not someone that the court chooses, not someone that the government chooses, not someone that Uncle Sal chooses or Aunt Sally chooses, but someone that you've chosen. But I also caution you, a power of attorney is probably the most powerful document you will ever sign, because you are allowing someone to be you in the financial sense. So it's very important that you make sure that you pick someone that you absolutely trust. I also point out just briefly what does the power of attorney do? Their duties sort of fall in three main categories, whether it be financial, real estate, and what we call estate planning. The financial is probably what you would expect, which is that your power of attorney or your agent under power of attorney can manage your bank and investment accounts. They can sign checks for you. They can open and close accounts, make sure your bills get paid, all very important functions. They also have the ability to manage your real estate. So if you have real estate and it needs to be sold, they can sell it. If you have rental properties, they can manage those rental properties for you. And then for estate planning, your agent under power of attorney has the ability to make certain decisions, whether it be over retirement accounts or insurance or whatnot. So it's important that you think all of these things through and who you um, want to receive things. Then, when it comes to healthcare, there are separate documents that you need to make sure that there's someone in place to make your healthcare decisions. So you need a healthcare power of attorney, someone who is authorized to make decisions for you when you're not able to. You can always make your healthcare decisions, but there can come a time when 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 we can't provide informed consent to medical procedures or surgical procedures. And that's the point when you want to make sure that you have someone appointed, someone you trust, someone who shares your values, so that those decisions can be made. Second is your healthcare agent needs access to your healthcare information. So how do we make sure that happens? You need to also sign a Hipaa authorization. Probably all familiar with Hipaa authorizations because we sign them when we go to the doctor. But it's important we also include these Hipaa authorizations in our financial power of attorney and in our healthcare power of attorney to make sure our agents have the authority to get the protected health information they need to do the job you've asked them to do. And then the last two, to a certain extent, go together. A do not resuscitate order that allows states that you don't want to be resuscitated if you're suffering from an end stage condition. And then the living will or advanced healthcare directive, which goes hand in hand with a DNR, or do not resuscitate, which says which says that if you're suffering from an end stage medical condition, state of permanent unconsciousness, so such as a coma, that you don't want your doctor to continue to provide you with curative care and treat you when you're not going to be able to come out of that illness, that the doctors have determined that you're going to die no matter what they do. Essentially you want to be able to pass away peacefully. Well, it's important that you have these wishes written down so that your doctors, the hospital knows, and also so your loved ones know. Okay, so the next section we want to move on to is we want to talk a little bit about trusts. We could probably spend an entire 40 minutes to an hour just talking about trusts, but I just want to touch on it briefly, because and I'm going to say something that maybe you wouldn't expect an attorney to say to you, but not everyone needs a trust. Trusts are useful, but they are useful in very specific circumstances. And like I said, we could spend lots and lots of time talking about each of these circumstances. A trust will certainly allow you to care for special needs beneficiaries, to maintain some additional control, and to do some stage distribution. And one of the areas, and we'll talk about this more in a moment, is asset protection or Medicaid planning. So, like I said, there's three primary areas really when you want to choose a trust. A trust can provide you with flexibility in case of your disability, that you can exercise control and protection after your death. So like we talked about 10-15 minutes ago, making sure that your beneficiaries are protected. And the third is for Medicaid planning or asset protection planning or nursing home planning. I'd just like to take to pause here and just talk for a moment about beneficiary designations. So most of us have a 401k plan or an IRA or a life insurance. You may also have an account that says that is what's called a pay on death or transfer on death, that there's an indication on the account that if you die, that there's a beneficiary listed. It's important to note that these beneficiary designations are not controlled by your will. They are only controlled by the designations that you make with the plan administrator for these assets. So it's important to understand that these have to work in conjunction with your plan, and that you need to make sure that they are always up to date, and that changing your will is not going to do that for you. There are, of course, some risks of just using beneficiary designations, is that it doesn't take into account what happens if your spouse or beneficiaries become disabled. Because if you leave the asset to them, they're going to get it. It's not going to be subject to any trust provisions or any other provisions. And as a result, can cause some unintended consequences, especially if you don't keep them updated and maintained. So we can talk for a moment about some testamentary tools. These are tools of how you transfer assets upon death. We talked about a will and what that does. That establishes your inheritance scheme. It appoints your fiduciary, or the person who's in charge. And then there's two general types of trust that we'll mention. A revocable living trust is a substitute for a will. It does a lot of the same things. It can create some lifetime funding options. and can accommodate some more sophisticated planning for children, uh, for considerations for blended families or for special needs. It also does avoid probate. So there can also it can also enhance your privacy. And then we have your uh, irrevocable trust. Does not require probate. Now the grantor cannot make changes or amendments to it, but it can also provide for some asset protection for you as well. So these are all good tools, but they're tools that are used for specific circumstances. So they're not one size fits all. That's why it's important to have a customized estate plan made for you and for your family. So now I want to turn to some asset protection considerations. This is another area that we could spend probably an hour talking about and not feel like we've hit everything. But it would be I would be remiss if I didn't talk about this for a few minutes in a seminar such as this. So, average cost of nursing home care in Pennsylvania is $10,000 a month. I'm going to say that again, $10,000 a month. The average nursing home stay is about 3 years. You could wipe out your entire life savings in a nursing home. So it's important that we talk about how you pay for this long-term care. So 4 primary methods. Self-pay. Well, not everyone has the ability to afford, $10,000 a year, $10,000 a month, $120,000 a year. Maybe you can for a short period of time. Long-term care insurance can help and can reduce some of that cost, but typically long-term care benefit is not going to cover all of the care or all of the cost of your care. Medicare. Medicare is a great program. It does a lot of things. It doesn't cover long-term care. It is a health insurance program, not a long-term care insurance program. Medicare will pay for some short rehab stays in a skilled nursing facility, but those are stays that are rehabilitation, that are designed to be curative. Once you stop making progress and your stay is transformed into a long-term care stay, Medicare is no longer going to pay. Then you have medical assistance, which is a needs-based safety net program. It is the Medicaid program. So in order to qualify, you essentially need to have less than $8,000 of assets and all of your income less around $45 a month is going to go towards the payment of your care. Now and then finally, I also will mention that there are veterans pension programs or veterans pension program. This is helpful in defraying some of the cost for aides to come into your home or for assisted living or whatnot. Once you go into a skilled nursing facility and you need medical assistance benefits, you cannot continue to collect the veterans pension. All right, so the modern estate plan, it's not just let's write a will and be done with it. There's a lot of things to consider. There are will-based plans that you can utilize, but it's not just about a will. It's the will is a great tool, but you also need to plan for what happens in your life as we're all living longer. We need to make sure that we have our healthcare decisions made, and that we have created a directive, and we've appointed someone who can make those healthcare decisions if we're not able to, they can get that healthcare information that you need, and that you have someone who can make financial decisions for you. Our assets are not all covered by a will, so we need to make sure that we have our beneficiary designations up to date. And then we need to think about, do we need something a little bit more sophisticated? Do we need something? Do we need a revocable trust? And then that involves retitling assets, or whatnot. So these are all things that need to be you need to think about. The modern estate plan certainly requires, some consideration, and you need to consider all different aspects of life, not just your death. So when should you plan? Well, you should always have a plan. You don't necessarily need to wait for a major life event, but if you have a major life event such as the birth of a child, grandchild, purchase of a home, those are all good times to plan. But everyone needs a plan to me, not just, as I mentioned, for their death, but also for their life. And your plan is not a once and done, because life changes, and you need to make sure that your plan changes with your life. Maybe your assets have changed. You made a will when your kids were 4 and 6, but now they're 46 and 50, and you need to make sure that your plan has evolved with you and with your family. You want to make sure that the people that you've designated as your power of attorney, your trustee, your executor, are those still the right people? Did you appoint your best friend from high school who you stayed in touch with but haven't spoken to in 10 years? Then you want to make sure that you make a change. You want to make sure that your plan includes comprehensive planning for disability, because a will is great, but what if what happens is that you don't, not necessarily that you die, but that you become ill, you become incapacitated. You want to make sure you have a plan for all of these areas. So what should you think about when you're choosing an attorney to help you create your plan? You want to make sure that the attorney you're working with really is an expert in their field. You want to make sure that their primary focus is on estate planning, because as we talked about for the last 40 minutes or so, there's a lot of moving parts and it can get complicated. And you want to make sure that you're working with someone who has a handle on all of these different parts. You want someone who charges you a flat fee. This way, you know what those costs are going to be upfront, so that you can plan. You want to make sure that the person that you're working with, or the attorney that you're working with, practices a collaborative based practice. You want to make sure that they're going to work with your other advisors. They're going to talk to your financial advisor. They're going to talk with your life insurance counselor. Make sure that they are going to be part of your team to make sure that you achieve the results that you're looking for. And you want to make sure it's someone who understands that creating a plan is part of creating a long-term relationship, because you want to make sure that your estate plan stays up to date, and you don't want someone who's just gonna write your documents and then say see you later, and not have any more involvement with you. And lastly, you have to like the person you're working with, because if you don't like them, you're not going to talk to them. You're not going to tell them things that are going on that are important in creating your plan. So then a little bit about our firm. We are licensed in Pennsylvania, New York, and New Jersey. Our firm opened around 1946. Obviously, I have not been there since the beginning. Otherwise, I would probably have a lot more gray hair than I do now. And we have a team of support staff. We can get your plan done typically in about 3 to 4 weeks. We do we do provide in-person consultations in our Wyomissing and Hamburg offices, but we also, excuse me, have the ability to work with clients using phone and Zoom until we get to a signing meeting, and then we typically will ask you to fill out a questionnaire. We'll provide you with drafts to review, and then we will coordinate the signing. We can do that in person or in one of our offices, sometimes at your home if that's necessary, or we can do that. We can coordinate so you can do that on your own, and we can send you a mobile notary to assist with that process. At our firm, we also have a legacy protection plan, which helps you keep your plan up to date. So that plan does include review meetings with the attorney, digital storage of documents, annual conferences with your advisors to keep your plan up to date, and a maintenance of an asset spreadsheet. This is all designed to help you keep your plan up to date, so that it can continue to live and grow with you. So next steps, I'm going to put into the chat a link. You can schedule an appointment with us so that we can do a complimentary design meeting. Find us on Facebook, like us, watch your email for the opportunity to schedule consultations. And that brings us to the end. So we went back in time there. So if you have, I appreciate you being here. If anyone has questions and you want to put those into the chat, please feel free to do so. And then again, thank you for being here. Again, I'm Russell Farbiarz, estate planning and elder law attorney at Antanavage Farbiarz. Okay. Regina Reinheimer has raised her hand. Now I need to know what to do about that. Let's see here. Regina, did you have a question? Or maybe not. Well, oh, chat is disabled. All right. Well, everyone will get a. I'm going to put that in the. I'll put the link into the question and answer, so everyone should be able to see that now. But thank you, Regina, for letting me know that that the chat was disabled. But if anyone has any other questions, you can always reach out to us via email, as well as via phone 610-562-2000. And then thank you everyone, and I appreciate everyone being here today.